Okay, hi everyone. Thank you so much for joining us. We have a really exciting show for you tonight, and I'm just I'm really excited that you're here because this is going to be incredibly interesting. So my name is Lulu Freistadt, and I am the executive director of Smart Elections, and we are an organization that is dedicated to elevating election reform to an urgent national priority, which it very much needs to be. And we have been having election protection forums since July, every other Tuesday, and we're really glad that you're joining us. Tonight, we're going to talk about legal strategies that could affect the outcome of the election. And we're going to have an expert with us, a legal scholar, Professor Edward Foley, and he'll be joining us in a few minutes. But I just want to start, go over some of the projects that we're working on here at Smart Elections. And I also want to give you an update about a very important legal case in Georgia. So we thought that we were going to have Marilyn Marks, who is the executive director of Coalition for Good Governance, on tonight to talk about court cases that she has been pursuing in Georgia against the voting machine vendors there, and also against the Secretary of State, who has been putting these voting systems into play. And they had a ruling that it looked like kind of went against them because they were asking for the new ballot marking devices that had been implemented in Georgia that were very insecure to be put aside, and for the state to use hand-marked paper ballots instead. And I want to just read you the statement from Marilyn. She could not be here tonight because they actually had an immediate, urgent need because the case is ongoing. And so she just wrote to us, and I just want to read you what she wrote. She said, "Lulu, I am so sorry that I cannot join you tonight to update everyone on the chaotic situation in Georgia." To update everyone on the chaotic situation in Georgia and our lawsuit. But the court has given us a small window of opportunity to do some test scanning of absentee mail-in ballots that are not being scanned at proper quality settings, and therefore valid votes are not being counted. So she and Hari Hursty, who is a hacker that many of you are familiar with, they are on their way to test these scanners in Georgia as we speak, and the court has asked for specific recommendations on what the scanner settings should be. So she and Hari Hursty are going to get to give input on how sensitive these scanners should be. If you watch some of our previous episodes, then you know that the scanners in Georgia during the primary were set so high that there were many valid votes that actually weren't counted. And we had people who were at their audits, at their review board, and told us about that, about how the ballots were not being counted correctly. So they're trying to remedy that. And then what she went on to say, while we are disappointed in the court's October 11th ruling denying the motion that we made to have the state abandon ballot marking devices other than for accessibility needs, I urge you to read the court's 147-page ruling. It is clear that the court has adopted our view that the BMDs are not reliable, not secure, and the results that they produce cannot be audited. So what she's saying basically is that the court is moving in their direction. She said that they did not want to make a last-minute change of having the ballot marking devices removed from the polling places, but this is her statement. It seems clear that another round of evidence will win the day, and we are prepared to continue to move forward, conducting additional discovery, particularly during the chaos that is very likely to happen on November 3rd. So what she's saying there is they are basically full speed ahead on that lawsuit in Georgia that many of us are following. She's conducted, I think she's filed 6 lawsuits at this point against the various voting systems in Georgia because they are incredibly insecure, and they have been proven time and time again to be insecure. And she's had expert witnesses testifying to exactly how incredibly insecure their voting system is. And so we will follow that with interest, and she promised that she'll come back and talk to us at a later date. So I'm just going to give you one other update about a project that we're working on, and then we're going to move forward with our guest. So Smart Elections is coordinating a project called Count the Vote, and we're using that hashtag, Count the Vote. And I'm going to just show you a little bit of what we're up to with that. So here's our hashtag. And I'm going to share our website with you so that you can see what we have going on. And I'm going to encourage you to join us in this project. We had people on last time talking about it. And so this is our website, and you can find it if you go to Smart Elections /Count the Vote. And we are collaborating with many other groups across the country to try to gather evidence that will either confirm that the results are accurate or locate problems if there are problems. And there's a couple ways that we're doing that. And one is to take photographs of poll tapes. And many of you may remember when we had Benny Smith on, the reason why we take pictures of poll tapes is because sometimes we have found that the poll tape, which gives you the number of votes that the machines counted on election night, sometimes those results do not match the results that are reported. And this is in particular, this is a poll tape from Memphis, Tennessee in 2015, where the results that were reported were actually 40% less than what the poll tape showed on election night. Benny Smith took this photograph. And so what we're encouraging people to do around the country is to go to their local elections at the end of polling and take photographs of poll tapes. And we're going to teach you how to do that. So there's training coming up, and you can sign up on the website. There's 2 different trainings coming up this week. You can get the poll tape training on Friday at 1 p.m. Eastern time, and you can get the data training on Wednesday at 1 p.m. Eastern time. And we encourage you to sign up for one or both of those. And if you want more information on that, I'll just give you you're just going to go to our website, which is smartelections.us, and you are going to go to Take Action and choose Count the Vote. So that's Count the Vote is what you're looking for there to sign up to participate in that. And if you are in a state where this work is going forward, and that includes, let me just pull that up again. We have groups working in Georgia, in Florida, in Michigan, in North Carolina, in New York, in Philadelphia, and also a group working just to help coordinate things across the country. We have their contact information on that page, so you can go and you can reach out to the group that's working in your state, or possibly if there's a state that, if there isn't a group working in your state, then you can sign up for a state that you're interested in working in. So please do join us in our Count the Vote project. We're really just getting it underway, and it's a pilot project in beta, so we're just figuring things out. But we think this is going to be one way to really help ensure that we have evidence that the results are accurate, or if there are problems, that we can locate the problems. And there's a number of other things that we're doing, but the poll tapes are one way to get involved. So I am going to go right into our main feature tonight, which is that we're going to be discussing what is going to happen in this election. And it is a pleasure now to bring on Professor Edward V. Foley, and to have him here with us. Do you want to just introduce yourself and say a little bit about your work?
Sure. Thanks so much for having me. I'm delighted to be with you. I teach election law. I've been fortunate to be at Ohio State for many years now, and it's been a great home. Ohio has been a laboratory of democracy and voting issues We're not quite the battleground that we were.
I like
but
that laboratory of democracy. A little bit euphemistic there. We've had some
there,
definite
right?
bumps in Ohio.
Yes, indeed. We've been through the ringer. We feel for Pennsylvania this year, right? We know what it's like to be under the microscope.
Okay, so Pennsylvania is in your sights. I can tell, and we're going to talk about that. And then just a little bit about your background. I know that you also are a contributing columnist at the Washington Post. You had a really interesting article in the Harvard Law Review blog this just a few months ago.
Yeah, so I've been doing a lot of work over the last few years on issues related to recounts and the risk of disputed elections. And so, one of the I dwell on these awful things that might happen because I like to avoid risk or figure out how to solve problems. It's like, if my field were hurricanes or wildfires or any other kind of disaster, you want to avoid a hurricane or plan for how to mitigate it. And so election meltdowns or election disputes are a kind of emergency circumstance that affects democracy. And so how do we protect democracy from the emergency situation where it could break down? That's sort of how I see a lot of my scholarship. I wrote a book a couple of years ago called Ballot Battles, which was the history of disputed elections in the US, starting with the founding era all the way through Bush versus Gore. The Hayes-Tilden election of 1876 figures prominently, and we may end up talking about that.
Yeah, so let's start with that. And I actually, when we spoke previously, you suggested that I download and read that chapter, so I did read it. And oh my God, what a ride. So I am really hoping that we are not in for quite that rocky of a ride. But so you said to me that the Hayes-Tilden election is really the election of note. This is one that we really have to pay attention to if we are concerned that this particular election is in jeopardy of being contentious, of potentially straining our actual constitutional, structure. So tell us why that Hayes-Tilden election is so critical.
Yeah, so I never learned about it in high school class or college or anywhere. So I had to discover this for myself. And it's quite an episode in our history that I really think Americans should know about because it's an interesting story. It's kind of riveting drama, but it tells us a lot about ourselves in multiple ways. I think we don't teach it because we're a little embarrassed by it, because with the resolution of that presidential election, we ended Reconstruction. And the end of Reconstruction meant the end of civil rights and voting rights for African Americans in the South. In essence,
there was a deal that went down in order to basically forestall the constitutional crisis. There was some real kind of backroom dealing that went on.
Exactly. Yes, there was a backroom dealing in a hotel room. And it did, basically the Republican Party of the time, which, remember, the Republican Party, the party of Lincoln, was the party, and Ulysses Grant was the outgoing president, and he had dedicated 2 terms of his presidency to try to vindicate the 15th Amendment, which was equal voting rights regardless of race. He tried to use the federal troops, and he had been a general, of course, in the Civil War, and he wanted to use the troops in peacetime to protect civil rights and voting rights. But that legacy was disappearing as the resurgence of white supremacy in the South was taking over. They called it the Redeemer movement, and the Redeemers wanted to redeem the South. And in essence, the bottom line was that the Republican Party got the presidency for another term, but gave up on civil rights and voting rights. So it was a compromise, but it was an ugly one and a tragic one. So that's kind of the big picture.
All right, so let's just back up a little bit, because I think we're sort of at the end of the story, and I want to start at the beginning of the story. And the beginning of the story is that the Hayes-Tilden presidential race was contentious and tight, And we were in, similar to what we are in now, a very polarized country. We had just come out of the Civil War, pretty much, maybe like 20 years or so earlier, 15 years.
10, basically 10 or so, yeah.
10, okay. And then, and I'm gonna just kind of pull up, I think I can do this, pull up some of the text from your actual book on this, and it's so interesting. And what you said there was that the whole electoral count would have come to a halt with no apparent way to end the stalemate before March 4th. So this was like a huge constitutional crisis that developed, basically.
Correct. Right. That I mean, I do think we were right to start at the beginning before Election Day and follow the dispute all the way through. But because it's not meant to be a mystery novel, the really important fact to know is that the dispute was not resolved until March 2nd, the early hours of March 2nd. And Inauguration Day back then was March 4th.
Right. So this was different. Now our inauguration date is January 20th. But at that time, it was in March. So this would be as if things were still unresolved as of January 18th. And I want to just go through a few of those details because they're really fascinating. So what basically happened in 3 southern states, they sent 2 separate sets of electors to the Congress. Is that correct?
Correct. That's exactly right.
And what happened with, when they did that?
So let's focus on Florida. Interestingly, Florida was the focal point of the 2000 election, which people may remember. And part of the reason why I want to emphasize the importance of Hayes-Tilden in 1876 is not only was it so momentous for so many reasons, and it was our worst situation in terms of coming up to near Inauguration Day, but because those of us who have memories of 2000 may be lulled into thinking that's how a dispute goes. It could go that way, but the 1876 way is very different. So that's why I think it's important to know that history and think about it. But
okay, and so let's just, there's people on this call probably who don't remember Florida 2000 because, so we have voters, first-time voters who don't remember that. In Florida in 2000, there was a huge problem. The Democrats and the Republicans both thought that they had won Florida. They both needed Florida to win the presidency. They went into a hand recount, which was highly contested. There were people, mobs banging on the doors trying to stop those votes from going forward. And eventually the Supreme Court stopped the vote from going forward because they said, we're out of time. That's it. Clock's run out. We're going to declare the Republican, Bush, the victor in Florida, which gave him the presidency. Al Gore accepted that, and it was over. But that was not a constitutional crisis in the sense that it was resolved before the time for the president to be inaugurated, and both candidates came to an agreement. One candidate conceded, one candidate was a victor. And it was horrible for people who thought that the whole process was a mess and tainted and partisan. But as you said, it was done in time.
Right. I mean, the key thing about Florida in 2000 was that Al Gore conceded defeat in December before the meeting of the Electoral College. Because again, we as citizens, we vote, we think we're voting for president, but we're voting for the electors who are, going to vote for president at the meeting of the Electoral College. This year, that's Monday, December 14. It's always in December.
So that's a big date for people to remember. December 14th is the day by which the electors have to be chosen in every state.
Correct. And that principle that they must be chosen by date is how the Hayes-Tilden dispute ultimately gets resolved, or at least it's the key part of it when it goes to Congress. So, but to step back for a second, here's the key difference between 2000 and 1876. 2000, it ends when Al Gore concedes before the Electoral College meets. So it never gets to Congress. It never becomes that constitutional crisis, like you said. On the other hand, what happens also in Florida back in 1876 is that the dispute isn't contained within Florida. You don't get a concession based on the counting of ballots in Florida. Instead, what happens on the date that the electors have to meet, both groups of electors met, claiming that they're the official ones. So the Republicans electors all met in Tallahassee, the state capital, and they voted for Hayes. And they claimed that they were the true electors based on what the Secretary of State said. And then the Tilden electors, the Democrats, also met in Tallahassee on the same day, voted for Tilden, and they had the Attorney General from Florida saying that they were the valid electors.
And what you said in your book also was both of these, that there was there was fraud. So in the Republican decision about, in deciding their electors, they threw out a bunch of Democratic votes that they didn't want to count and counted a bunch of Republican votes that they wanted to count. And then the Democrats maybe had been more technically accurate about counting the votes, but had blocked Blacks and African Americans from voting, period. So there was really fraud on both sides in that situation. So who was more fraudulent, who was more wrong? Hard to say, but they both sent these two sets of electors to Congress, as did two other states, right? Which other states?
Louisiana and South Carolina were the other southern states where there were similar disputes. And then Oregon also had a dispute that was a little bit different. What happened was the Tilden team they thought that the Republicans were being fraudulent in the South, like we were just talking about. And they thought they had a trick up their sleeve. They thought, well, if Congress approves the Hayes votes from the South on a theory that the governor gets to sign the certificate of who's authoritative, we can play that game in Oregon, because the governor of Oregon was a Democrat on the Tilden side. So he manufactured just one extra electoral vote out of Oregon in favor of Tilden on a complicated technical theory that we don't need to go into. It was no doubt that the citizens of Oregon wanted Hayes, but they had a technicality where they basically tried to disqualify one of Hayes's electoral votes from Oregon and substitute a Tilden vote. And they said, if your theory in the South wins, our theory in Oregon wins. And the Tilden team only needed one more electoral vote of all the disputed votes to reach an electoral college majority. Hayes had to win every single disputed vote in order to prevail. And so that's why there were these 4 states that sent conflicting submissions to Congress to resolve.
And yet, at the end of the day, even though Hayes had to win all 4 of those states, he did it.
He did it, and it's an interesting story. When the fight goes to Congress, there's a deadlock, because under the 12th Amendment of the Constitution, which says that a special joint session of Congress is responsible for receiving the electoral votes from the states, opening them up, and then declaring the winner. But it doesn't specify how this is to be done. It uses the passive voice. It says the vote shall be counted. Now, my 6th grade English teacher told me, never, ever use the passive voice if you want to be clear. But our Constitution on this very important issue of counting the presidential votes that come from the states says they shall be counted. Doesn't really say by whom. And so what happened in Congress was, Congress being a bicameral legislature, both the Senate and the House wanted to play a role, and there is supposed to be this joint session where both chambers at least look at the returns that come from the states. But the Senate was in Republican hands and the House was in Democratic hands.
Identical to what we have now. The Senate in Republican hands, the House in Democratic hands. And to this day, has that part of the Constitution been clarified? Or are we still in this very nebulous territory where if 2 sets of electors are presented, it says it shall be counted, and it doesn't say by whom?
Correct. We have never amended this part of the Constitution, unfortunately, even though we've known. There was a famous justice on the Supreme Court in the 1830s named Joseph Story, and he wrote commentaries on the Constitution. And he said, yikes, I mean, I'm paraphrasing, but basically he said, yikes, this is a problem that's going to happen. Well, he was right. It happened in 1876. We've still never fixed it by constitutional amendment. We have a statute that was adopted after the Hayes-Tilden fight that we can talk about, a statute that still would apply today, but the constitutional ambiguity still exists and is dangerous. If we really wanted to avoid another risk of the Hayes-Tilden type problem, we would fix this ambiguity in the Constitution.
And I just want to read this one part of your book. The ensuing session has been deemed probably the stormiest ever witnessed in any House of Representatives. One of the obstructionists, that was the Democrats, climbing across 4 desks, hurled himself at Speaker Randall in an effort to force the Speaker to adopt their position. Some of the members grasped their revolvers, and ladies, fearing a free fight was about to occur, left the galleries. So this was very passionate, this debate, and potentially—
Don't you think there should be a movie? Don't you think we need a movie? Isn't that a scene that is worth putting in a movie?
Yeah, definitely. I'm definitely interested in the casting on that. But this was a potentially violent, passionate debate that was eventually resolved because of this very kind of nasty backroom dealing where the former slaves were basically left to fend for themselves in the South in a swap that gave the Republicans the presidency. So that's how that was resolved. So let's move forward now and talk about what we've got going here, 2020. I know there's 2 states that you're particularly concerned about. Can you talk to us about what those 2 states are?
Yeah, I'm most concerned, I think, about Pennsylvania and Wisconsin. But frankly, you might add North Carolina to that list. Maybe Michigan. Any of the battlegrounds that are closely contested that could be pivotal to an electoral college winner, in theory, could be a source of dispute. I mean, the very fact that Hayes-Tilden had 4 states that got disputed in Congress means we can't rule out the possibility that it could be 4 states this time, not just one like Florida. It could be multiple battlegrounds. But if I had to put one state at the top of the list, it would be Pennsylvania.
Okay, and tell us why.
So first, if folks ever go to the website 538, that's the Nate Silver's prognostication. He looks at all the polling data. He's identified Pennsylvania as the most pivotal state in the Electoral College. In other words, if we get a really close election, Pennsylvania is probably the one that puts a candidate over 270 one way or the other. So that's a reason to focus on it in and of itself. But another reason is its legal infrastructure, in my judgment. I live in Ohio. I just look at the laws that are available to anybody publicly. But my analysis makes me think that Pennsylvania is potentially more vulnerable to litigation that could give the state a hard time. Another reason is that unlike Florida, which has been a battleground for so long, or like Ohio we talked about, those states have been tested time and time again. And with every lawsuit, you eliminate a problem by settling the issue. Lawsuits thrive on ambiguity because that's what you litigate over, uncertainty in the law. And Pennsylvania, although it was something of a battleground in 2016, its status came a little bit as a surprise. So if we think about 2000, 2004, 2008, Florida and Ohio were the battlegrounds, Wisconsin to some degree. Pennsylvania is a newer battleground and therefore may be more vulnerable to litigation that discovers problems that haven't yet been solved, that if they spin out of control could cause a real problem.
Okay, now I know you said that you don't want to get too specific because you don't want to give any side any ideas, but can you walk us through it a little bit in whatever detail you're comfortable with? What type of scenario could happen? Like, how would this go forward? We're in early voting now in many states. I believe that Pennsylvania has early voting. And so they're gonna, count those votes on election night, and then there's gonna be mail-in ballots. And then what could happen that could somehow allow Pennsylvania to produce 2 sets of electors and send those to the Congress?
Sure, and I want to preface what I'm saying is I study elections because I want elections to work for voters. I try to be very nonpartisan because I think voters should get their choice. And so my view is that elections work well when the voters do get their choice. So to me, it would be a defeat of that freedom of choice on the voters' part if for some reason there's a failure that the electoral votes of Pennsylvania are not based on the popular vote, but are based on something else. So how could that happen, or how could that create a problem? I think there's two ways to think about that. One is if for some reason the legislature in Pennsylvania doesn't trust the counting of the popular vote and decides to attempt to repudiate the certified result that administratively occurs in the local boards of elections and under the auspices of this, what we normally think of as Secretary of State, but in the Commonwealth of Pennsylvania, it's the Secretary of the Commonwealth.
Now, the Pennsylvania legislature is controlled by Republicans, I believe.
Correct. And
okay.
So what I've written about in the past is there is this phenomenon that's emerged in the last 2 decades as a result of positive reforms designed to help voters and to improve the system that cause there to be a number of ballots that are unable to be counted on election night. They're valid votes, they're entitled to be counted, but they can only be counted subsequently during what's called a canvassing of returns. And that's before you get the certification of the canvass and the final result. Provisional ballots are of this nature. A provisional ballot, by definition, can't be counted on election night. It's provisional. It's got to be verified. I believe provisional ballots are an important reform because they are a safety net for voters who show up and have been erroneously purged from the voter rolls, as has happened in the past, and that at least allows them to cast a vote. And then if they can demonstrate that the purge was incorrect, their provisional ballot will count. So
but I think it's rare for provisional ballots to be in such large quantities that the outcome of the election of a state would hinge on provisional ballots. Are we more talking about the absentee ballots and the mail-in ballots that are going to be in much higher quantity than in previous elections because of the pandemic? Is that like the big bulk of votes that could, yes, in theory, be disqualified?
I think that's right. No, absolutely right. And I meant to only mention both provisional and, as you say, more importantly, the mail-in or absentee votes as two different categories that can't be counted right away on election night. Now, in other states, you can get the counting of vote by mail quicker if you allow for the verification process to happen on a rolling basis, as some states like Florida do. Pennsylvania has a law left over from its previous regime where you cannot begin to even verify a vote by mail ballot until the morning of election day. So that's why in Pennsylvania in particular, these ballots are going to pile up and pile up and cannot be touched until the morning of election day. And unlike counting an in-person vote, which is pretty straightforward on election day, all of these vote by mail ballots have to be verified.
Right. And what that means, and we had another show on this about signature verification and signature challenges. So each one of those ballots could potentially be subject to challenge. And the Republicans, if they chose to, could really drag that process out, challenging signature after signature after signature, delaying the process. And time is really of the essence, because if they don't have their electors chosen by this date that you said, December 14th, because this is dragged on and on and on, and they go to court and they challenge more absentee ballots, what happens? What is the result?
Yes, no, that is the second of the two things that really concern me, and I'm happy to take it first. And that is if these challenge processes bog down to the point where the state is unable to have a certified result of the whole popular vote of the state, then it can't appoint electors based on the popular vote. But that has to happen, as we were talking about, by Monday, December 14th. That is a hard deadline as a matter of constitutional law. Every state has to have its electors meet that Monday because the Constitution says it has to be the same day all around the country. Congress can pick the day, and Congress has picked December 14, but the Constitution requires no extensions. And
absolutely. That's absolute deadline. December 14th, you've got to have your electors picked, or the legislature can go ahead and just pick its own electors, because they've got to send some electors. And if they don't send some electors, they basically lose their votes altogether, right?
Exactly right. If Pennsylvania doesn't appoint electors, then it doesn't participate in the presidential election. It doesn't have votes in the Electoral College. New York, actually, in the very first election, where everybody wanted George Washington, New York failed to show up. They couldn't get their act together. And so New York never voted for George Washington. Didn't make a difference because he was unanimous, but it was kind of embarrassing for New York. I don't want any state to miss this deadline. And this deadline, the reason why Florida was decided for Hayes and not Tilden, to go back to that history, was because Florida attempted to change its result after the relevant deadline and say, oh, Tilden actually won Florida. And when it got to Congress, no, it's whatever is the rule in the state as of the date the electors meeting. So this year, focusing on Pennsylvania, if Pennsylvania has no answer by December 14, it has no electors, it has no electoral votes. And as you point out, that it's likely what would happen, the legislature would say, we need to step in. We had hoped to have a result by this crucial date. We wanted the local boards to count the votes and the secretary to certify. But if that's not going to happen, we're going to step in and appoint electors directly, because under the Constitution, the legislature can choose the method of appointing electors. They've chosen a popular vote, but Congress says if that fails, the legislature can step in with a substitute plan, and the substitute plan could be this direct appointment.
Right. The legislatures legally have the right to decide how to pick the electors. They have mostly chosen to decide to pick them by popular vote, but they legally have the right to pick the electors however they want, these state legislatures.
Correct. I mean, they can't violate collateral provisions of the Constitution, but essentially they have very great authority. And again, the key point is they could just pick them themselves.
Right. And I think many people might feel this was disingenuous. They're slowing down the process, possibly deliberately, and then they pick whoever they want because they're like, oh, well, look, the process isn't complete. But in terms of from the Republican perspective, there is a great deal of concern that all of these mail-in ballots are potentially fraudulent. And I mean, if you believe the Republicans, many people do not, but if you believe the Republicans, they themselves feel that they are being, that the election is being stolen from them with all of this absentee ballot voting, all this mail-in voting. So that is their at least public defense of this strategy, I think. Is that in the court of public opinion?
Yes, but that goes back to the first of the 2 points on this that I want to emphasize, which is there is the risk that even if the count gets complete, given that the count is going to be based on vote by mail, at least in part, there is the danger that the legislature could say, we don't trust the count because it's dependent on vote by mail.
I mean, how can they make that? How can they say, like, we don't trust the count? What is that? We don't trust the count.
Well, I don't think they should. And my view in a nonpartisan way is to say that the system should work for the sake of the voters. And so what I would say to anybody who is suspicious, to say you have to have an evidence-based reason to invalidate a ballot. Once you have and by the way, Pennsylvania moved to what's called no excuse vote by mail before the pandemic. Pennsylvania does not have universal vote by mail the way Utah does or Oregon does. Pennsylvania instead has the system that many states do, like Florida and Ohio, where a voter has to request an absentee ballot. They don't get it automatically, but they can request it for any reason that the voter wants, including just the voter's own preference. That's the concept of no excuse. Other states have adopted that, in previous years. Ohio adopted that back in 2006, has not had any problems with fraud. But Pennsylvania was planning to adopt that for the first time for this election before the pandemic. but they were probably not expecting the volume, because Pennsylvania has been used to a much more restrictive system where you needed an excuse, a business trip or hospitalization or what have you. So they were thinking that their previous rates of voting by mail was, under 5%, might grow a little bit. It's now going to grow significantly.
So it behooves the Democrats to do everything they can to really document that those mail-in ballots are legitimate, to make sure that with their voters, that they get their instructions right, that the signatures are correct, that all of those steps. There was actually a really funny video called Naked Ballots. I don't know if you saw it, but it was like a whole series of naked celebrities. And their whole point was not, because Pennsylvania has this thing where you have to put your absentee ballot inside an envelope and then inside another envelope. And if you don't do that, your ballot's called a naked ballot and it won't count. So I think the Democrats, as like evidenced by that naked video, are bending over backwards to try to get people to follow these rules and get those ballots to have the evidence that you're talking about so that they can be legitimate. But I want to just pivot a little bit. We spent a fair amount of time on Pennsylvania. Let's just talk a little bit about some of the other states, about Wisconsin. What are your concerns about Wisconsin? And then we'll take some questions.
Sure. Just one last quick point on Pennsylvania, and then we'll pivot. I think it is good that voters are doing what they can to avoid problems like the naked ballot. I also think that the law has in place the system that requires this verification process. So a ballot won't count unless it meets the requirements of the law. And that's why anybody who thinks that a ballot shouldn't count has to come in with extra evidence to disprove it, because the ballot already has to prove its validity. So that's why I think, assuming that Pennsylvania completes the process, as I hope it will, voters should be able to trust the certified count of the popular vote. And I think it would be a shame if the legislature repudiates that, because I think that would be a repudiation of allowing citizens to choose their president in the state of Pennsylvania.
I think there's a lot of things that both political parties have done that the voters have considered shameful at this point. So if our hopes are in the basket of, oh, if only our politicians won't behave shamefully, I'm afraid we may be disappointed. I think we are headed for some, behavior that many people will consider shameful coming up. But I think what we're trying to do here is educate people about the process, educate them so that they won't be surprised, so that they can participate. It sounds like it's very important for political parties, like if it's the Democrats who are defending ballots, to have their people in there defending signatures, making sure that challenges are met, making sure that voters have an opportunity to cure their ballot. So making sure that that those ballots, if they are challenged and disqualified for some reason, that the voter has the opportunity to then rectify that. I know some states do allow for a cure. I don't actually know if Pennsylvania does, but this is really important that the parties pay attention to these details, is what you're saying to us.
Yes, and you just said what I think is the most important big picture point. Again, elections should be run for voters, not politicians. But there is this mindset in our country, it's associated with gerrymandering, but other manipulation of the rules, that somehow the politicians are entitled to manipulate the process for their own benefits as incumbents or as partisans, so as to kind of take away the freedom of the choice from the voters. That's a mindset that is antithetical to the fundamental principle of government of the people, by the people, for the people. So I'm hoping that we can hold on to what should be the way we do things.
Okay.
But I hear you laughing.
I am laughing. I'm sorry. You seem lovely and horribly naive to me in saying that. We just seen so much bad behavior from our leadership in terms of doing what's expedient. But please, let's talk about Wisconsin. What about Wisconsin?
So similar, you've got polarization, right? You've got this incredible toxic environment where the legislature is in the hands of one party, the governor is in the hands of the other party, and here the state Supreme Court is dividing 4-3 on party lines on a lot of election-related issues and some other issues as well. And so you can imagine a scenario in which there's a fight over the ballot, the kind of ballots that we're talking about in Pennsylvania, but let's just transpose the kind of that same issue to Wisconsin. There's a fight over, Wisconsin has a witness requirement for absentee voting. Hard to do in the midst of a pandemic. So what if there's a lot of absentee ballots arrive missing witness signature, or there's just a flaw with that, or they're late because of the postal service having problems or some other problem, or just in Wisconsin back in April in the primary, which got hit hard with the pandemic, had huge rates of disenfranchisement, unfortunately, because the voters never got the absentee ballot that they requested. They requested them on time, and the local clerks just could not keep up. And so, you could have a situation where there's 10,000 ballots cast by eligible voters, registered voters, but technically deficient for some flaw, witness problem, lateness problem, something like that. What if the race is close? And these 10,000 ballots are going to make a difference on who wins Wisconsin. Suppose that goes to the Supreme Court and you get a 4-3 decision rejecting all those ballots, with the more conservative judges of the court saying the law is the law, strict rules apply. The more liberal judges saying this is disenfranchisement, it's unconstitutional, we should protect voters from problems that aren't their fault in the midst of a pandemic.
But in a case like that, I could see how in that case the Republicans control the Supreme Court, and these ballots get disqualified and they could win the electors. But I don't think in that scenario that they would send 2 separate sets of electors to the Congress. Do you?
Depends on what the governor is willing to do and how much hardball the governor is willing to play.
So play that out for us. How would the governor send a separate set of electors from Wisconsin, and what would happen in Congress?
So, again, I think, hopefully, again, none of this happens, and this is just these nightmare scenarios that we think about. And I think for this to gain traction in public discourse, the rhetoric would have to kind of take over that somehow this was voter suppression, and the disqualification of these 10,000 votes wasn't just following the rule of law, but was really voter suppression. What if this did fall more heavily on the minority community? What if these problems were in Milwaukee and not statewide? What if, so you have to kind of fill out the details of the scenario. But suppose the governor said, I don't trust this 4-3 decision. I think it was rigged, to use that provocative rhetoric. I think this was stolen from the people. This is a court that's run amok. I don't trust the court. And so I think, and let's just assume it's a Democratic governor saying, I think Biden would have won Wisconsin if the Wisconsin Supreme Court played fair, or if there hadn't been voter suppression.
Is the Wisconsin governor a Democrat?
Yes.
Okay, so we do have a split party in that situation. Okay.
Correct. And so that would be a little bit like Gay and Hayes Tilden, because then the governor could say, I want those Democratic electors to meet in Madison, Wisconsin on December 14. And you'd have 2 sets. You'd have the Republican electors meeting, claiming the authority of the state Supreme Court, purporting to act pursuant to the rule of law, making a decision even at disqualified votes. And then the Trump votes would go to Washington based on that decision. But then hypothetically, the Biden votes would also go to Washington bearing the signature of the governor, claiming that he thinks that the election was stolen.
Okay, so play this out for us. So we have 2 close swing states like Florida and Wisconsin, and you said also conceivably North Carolina, for example, and they all send 2 sets of electors to Congress. What happens?
Well, there was a statute that was written in 1887. So 10 years after Hayes Tilden that we were talking about. And it wasn't like Congress was twiddling their thumbs. They worked for 10 years to try to write a rule, but it was really hard. And they finally said, we got to have something. But they wrote a statute that, frankly, is very hard to understand. It's complicated, gobbledygook language. And you have to take it in two parts. You have to realize that the meeting starts, will be a meeting on January 6th. That much is clear. And it's both parts of Congress meeting in the same room. It looks like a State of the Union address. The Senate's there, the House of Representatives there. The presiding officer is the Vice President of the United States in his role as President of the Senate. So this is January 6th. So it's the new Congress, but it's the current Vice President.
Is this the right code?
That is it. Yeah. And if you look at all of those words, it's a challenge to get through all of that. If anybody goes to that website and scrolls down, you'll see it's a very long list of language. But just to simplify it as much as we can, Congress takes the states in alphabetical order. So starting with Alabama, ending with Wyoming. And since we were talking about Wisconsin, let's just focus on that. It could be Florida earlier in the alphabet. But if Wisconsin arrives and there are these two conflicting submissions, and the vice president has to announce, I'm in receipt of two submissions from Wisconsin, which is the correct one? At that point, the Senate leaves and goes into its own room to deliberate, and the House stays to deliberate because the two chambers deliberate separately. If both chambers agree, the statute says that agreement should control. So if you happen to have both the Senate and the House agreeing that the Trump submission controls, that would prevail. And by the way, there's another part of the statute which, if Congress is acting in a nonpartisan fashion, now you said I'm naive, so I'm not really expecting this to happen. But if Congress was being true to its own pledge about this thing called the safe harbor deadline, which is December 8, it's 6 days before December 14. And what it says is that if a state resolves a dispute by December 8 using law that exists on November 3rd, then Congress promises in this meeting on January 6th to accept whatever the state decides on its own and not to second guess it. So there could be a claim that the Wisconsin Supreme Court's decision, whether you like it or not, complies with that requirement. If it's done by December 8 and they are relying on law that existed by November 3rd, that would be the kind of dispute resolution mechanism that Congress has said we won't second guess. Now, I've been supposing that the governor is saying no. So what happens when you get to Congress? Now,
I think we lost Professor Foley for a minute there. Our connection is timed out. That's too bad because that's right at like the most. There, we lost you for a minute. Yeah, we lost you. We're like, what? We're just on the edge of our seat. So basically, I know we really just have like 2 more minutes because we have some other information that we need to get to about voters with disabilities, and we'll try to take at least maybe one question. But what you're saying is, so these disputed electors go to Congress, the Senate goes in its room, the House goes in its room. We know that they're going to make different decisions because the Senate is Republicans. And I had also heard from another attorney that the House actually is controlled by the Republicans because it's like 1 vote per delegation and the Republicans have the control of the delegations. But you told me that's not true.
So let me get to that in a second. But the real punchline on this key point is if what you say occurs, meaning the U.S. Senate wants to accept the Supreme Court, state Supreme Court's decision, and the House of Representatives wants to accept the governor's submission, the best reading of the statute that I can come up with and other scholars can come up with is actually the tie goes to the governor. That when the Senate and the House disagree, even if they should agree, the statute seems to say that whichever submission comes from the governor is the decisive submission. So in that situation, even if the governor shouldn't have acted contrary to the Supreme Court, the governor may be able to prevail if Congress is deadlocked.
And that might motivate the governor to step forward and challenge those electors, because technically he might think that he's going to be respected. So thank you. That's fascinating. So just clarify that point. Who's in control of the House? Is it the Democrats who have a majority, or the Republicans who have the delegation lead?
So on what we were just talking about there, it's regular procedure in the House of Representatives, each member having a vote. So if the Democrats keep the House, as they currently have, it would be the Democrats. But what the other attorney was talking about was a situation that it would apply. Remember how I said how under this special procedure, you take the states in alphabetical order from Alabama to Wyoming. If doing that, you put every state in one column or the other, even if it's disputed, you will get to an answer where one of the two candidates has an electoral college majority. Because take Wisconsin again. Trump wants it, Biden wants it. There's this complicated procedure, but if the governor's signature prevails, it will end up going in the Biden column if that's what the governor has signed. The other special procedure where only the House votes only applies if when you get to the end of the alphabet, all the way through to Wyoming, and you end up in a situation where no candidate has a majority. That's unlikely to happen in the kind of dispute that we're talking about. It didn't happen in Hayes-Tilden because Hayes got every disputed state. I think if we had another situation, again, it's a complicated process, but I think every disputed state's going to end up either for Trump or for Biden. So the only way I can see no candidate getting a majority is if we end up with a 269-269 tie. That can happen under the Electoral College because you could get 538 electoral votes. You could have a 269-269 tie, but that's unlikely. But if that happened, then you go to that other special procedure.
Okay, but in the scenarios that you are considering most likely that might develop in all of this, in most of the likely scenarios, the Democrats would retain their majority in the House, and the Republicans would retain their majority in the Senate. And is it based on the new elected officials? So is it based on the new vote, or is it a lame duck session?
No, it's the new. It's the new Congress takes office on January 3rd, and this meeting is January 6th.
So if the Democrats took the Senate and they had the House, and this went to the Congress, then the Democrats would decide it in their own favor, most likely.
Correct.
Interesting. Okay, let's just take one quick question from Chris Bystroff. Chris says, how many states have legislatures dominated by the party that is opposite the voter majority in that state? Are these states all vulnerable to the kind of defranchising that you are talking about? Does that make sense to you? He's kind of saying...
Yeah, it's a great question. I mean, obviously in swing states, purplish states, majorities can shift a little bit. But I think the key point here is that because of gerrymandering, that's where redistricting is done through political manipulation. We now have state legislatures that have benefited from this kind of gerrymandering. And so that's why you can have a situation where you have a governor elected statewide based on a new majority where the Democrats are preferred. So you have Democratic governors in Wisconsin, Michigan, Pennsylvania, North Carolina, and yet all those state legislatures are still in Republican hands, in large part because of gerrymandering. So that's this kind of conflict that could really be problematic.
Okay, and those were the 4 states that you did say that you're most concerned about: Pennsylvania, Wisconsin, Michigan, and North Carolina. And that's exactly the situation that Chris is describing, where you may have a majority of voters of one party, but the legislature is still in the hands of the opposite party. And we could see some real tension there. Well, thank you so much for being with us. It's really, really been interesting. And so just gracious of you to spend this time with us when I know how in demand you must be right at this very moment. So thank you so very much.
Well, thanks for having me. I really appreciate it.
Okay, take care.
You too. Bye-bye.
Okay, so I just want to play you guys a video right before we go. This has to do with disability rights. Very, very important. Voters with disabilities absolutely have the right to vote privately, independently, and we also like to make sure that they can vote securely. But in order for them to vote, they have to have an accessible voting session. And many times we hear from voters with disabilities that this is not happening for them. So I want to just play you this quick video, and it tells voters with disabilities what they can do if they are experiencing a situation where there is not an accessible voting system.
How to file a HAVA administrative complaint during a federal election. Brought to you by Disability Rights New York. Filing a HAVA administrative complaint is an important tool to advocate for disability rights. A complaint affords voters due process when denied access to a ballot marking device and provides an opportunity to share your experience with the state and local boards of elections. This ensures everyone has access to a private, independent, and accessible vote. So when you're at the polls this election, use a ballot marking device to cast your vote. What is a ballot marking device? A BMD is a device that allows voters with disabilities to mark their ballot privately and independently. However, everyone may use a BMD to cast their vote. If you are denied access to a BMD during a federal election, you may file a HAVA administrative complaint. You can file a complaint under any of the following circumstances. Your polling site did not have a BMD. Polling inspectors denied you access to the BMD. The BMD was not turned on or ready to use when you arrived. The BMD malfunctioned and caused delay or required you to mark your ballot with a pen. The BMD was not positioned to provide privacy. The BMD did not have enough space for a wheelchair or walker. An accessory to the BMD was not available. To file a complaint, you must first complete the New York State Board of Elections HAVA Administrative Complaint Form at www.elections.ny.gov/HAVA.html. Next, you must have the form notarized and submit the complaint to the New York State Board of Elections within 120 days of the violation. As part of the administrative review process, you are entitled to a hearing before the New York State Board of Elections. Hearings are conducted in accessible formats, including in person, over the phone, or by video conferencing. While not necessary, you are entitled to bring support to the hearing, such as an advocate, family member, or a witness to the violation. For assistance filing a HAVA administrative complaint, please contact Disability Rights New York at 1-800-993-8982 or voting@drny.org.
So that's really important. If you are a voter with disability, or even if you're not a voter with a disability and you see that there isn't disability access at a polling station, or you notice that the ballot marking device isn't plugged in or isn't operational, absolutely bring that to someone's attention. And if need be, you can file a HAVA compliance complaint. And in some ways, that may be the only way to really change that. We do hear on a regular basis from voters with disabilities that this is an ongoing issue, despite the fact that since 2002 it's been required. They are still experiencing problems having an accessible voting session. And we will put that information on our website so that people who want to follow up with that will have that. I want to just say, I want to thank you so much for being with us and give you ways to get in touch with us. So our website is smartelections.us, and I'm Lulu Freistat. You can follow me at Lulu Freistat, and you can subscribe to our YouTube channel. I put all of these links into the chat. at the top of the show. We are on Twitter. We are on Facebook. Please like us on Facebook. Please follow us on Twitter. And we are also on Instagram. We are also on TikTok. And we need your financial support. So please do go to our website and click on donate. And we are encouraging you to become a tax-deductible monthly subscriber. And what about a small amount, like $5 a month? Our goal is to have small donations to the point where we can sustain ourselves for our ongoing work. And some of the work that we're doing is, like we had a really great session on hand-counted paper ballots last week, and we are going to be working on a manual coming out of that by two of the top experts in the country, Virginia Martin and Karen McKim, on hand-counting paper ballots. And we are also doing our Count the Vote project that I told you about at the beginning of the show to try to monitor and protect the results. So all of your the funds that you donate go to make this work happen, and we really do need your support. And it is happening, actually. Thank you so much to everybody who donated so far. Every day usually, or every couple of days, I see that someone else has made either a donation or a continuing donation, and it really, I'm so grateful for it. It definitely lifts my spirits and makes me know that we can keep doing this work. So I think that's it for us. We just went a little bit over time, but thank you all so very, very much for being with us tonight. Please make sure that you sign up for the next forum. It is going to be, instead of on Tuesdays this time, it's going to be on Monday, November 2nd, because of course Tuesday is election day. So we're going to have a lot of information for you, especially about the Count the Vote project and where it's happening all over the country, and get you up to date on that and show you what we're doing. And we'll have whatever urgent election protection issues or election issues that we need to discuss. So November 2nd is our next forum. Sign up. And make sure to join us. The easiest way to sign up is at our website. Again, I'm Lulu Freistadt. I'm the Executive Director at Smart Elections, and thank you so much for